Good afternoon all. My name is Liana Janse van Rensburg, and I would like to welcome you to this afternoon's webinar, Prep for POPIA. With the commencement of the Protection of Personal Information Act on the 1st of July 2020, industry in general has shown not only mixed emotions about this new law that is officially now in play, but has also illustrated that there is a need for more clarity and a better understanding of what compliance with POPIA entails. Cloud Essentials, in partnership with Microsoft, is here to shed some light on some of the very daunting compliance requirements of POPIA and to provide industry with some guidance to optimally utilize the grace period the regulator has allowed for. POPIA requires all businesses to identify, assess, and manage their organization's needs in terms of data protection and privacy. Today's session will be brought to you by Chris Hathaway, our Operations Director for Cloud and Governance Services, as well as Kelly Chalom, our Head of Legal and Compliance. Kelly will take you through the key features of the Act as POPIA places different responsibilities on the various individual role players involved in processing and handling personal information, clearly defining the do's and don'ts. Once the legal stuff is out of the way, she will run you through the top tips to prepare you and your organization for compliance. Chris will then show you how to marry tech with the law. POPIA compliance cannot be viewed as a static once-off event, but should be viewed as a journey of continuous improvement. And what a better way to embark on such a journey than with technology you already have on hand and understand. This dynamic duo will introduce you to POPIA and show you what is required to be compliant and how you can achieve it with your existing Microsoft suite. So without any further ado, here is Kelly Chalom from Cloud Essentials, our compliance guru.
Thanks, Liana. Okay, so as mentioned, POPIA is South Africa's data privacy and protection law, and one of a growing number of similar laws being enacted around the world. During the course of this webinar, we will be firstly introducing some of the core concepts of the Act while asking the 5 W's, the when, who, where, what, and why. I'll then explain some key features of the Act, such as data subject rights and the obligations they impose on the parties actually processing that data. Bear in mind that this is a high-level introduction into some important topics and not a full assessment of the Act. I'll also be giving you some top tips to get your organization started on its POPIA compliance journey. And finally, Chris will take a look at some of the technology available to help you along in the process. At the end of the session, we'll be answering some of your questions around POPIA and data privacy. The right to data privacy sits at the very core of the legislation, but it's important to realize that as with all rights, not only must it be protected, it can also be limited in certain circumstances. Also, complying with POPIA is not a once-off event. It's an ongoing process that requires regular review of controls to ensure there's suitability, adequacy, and efficacy in protecting the data. Finally, compliance with POPIA does not guarantee that your organization will be immune to data breaches. Rather, the legislation aims to ensure that organizations apply appropriate and reasonable measures to prevent, detect, and respond to these incidents. As we saw with the incident on the weekend, even organizations with the most stringent controls can fall victim to data breach events. Okay, so let's start with some of the important concepts and the 5 W's of the Act. Firstly, when will the Act apply? Although POPIA was enacted back in 2013, the majority of the Act came into operation on 1 July 2020. Among them was Section 114, subsection 1, which requires all processing of personal information to conform with the Act within a year of coming into operation. This means that organizations have until the 30th of June 2021 to comply with POPIA. Who does the Act apply to? Whenever the Act refers to a person, unlike GDPR, POPIA is referring to a natural or existing juristic person. Natural persons are humans like you or me. A juristic person is an association of people that exists legally separately from its members, such as companies, state-owned enterprises like Telkom or Eskom, and non-profit organizations or non-governmental organizations. The main players under POPIA include the data subject, the responsible party, and the operator. Now, the GDPR and other data privacy laws around the world refer to the latter two parties as the controller and processor, respectively. The data subject, simply put, is the person whose information the law is seeking to protect, and this is the person to whom the information relates. In practice, this can be a natural person or a juristic person. So, for example, if your organization is responsible for protecting the information relating to your supplier organizations, such as their bank account details or VAT numbers, but you're also responsible for protecting information relating to the people at those entities with whom you interact, such as their phone numbers and their email addresses. The responsible party is, as the name would suggest, responsible either alone or with others for determining the purpose and means of processing, namely how it is going to be processed and for what purpose. And purpose is important, as we'll talk about a little later. The operator is that person who actually processes the information on behalf of the responsible party. It's very important that organizations are very clear on the capacity in which they act, as this impacts their obligations and their liabilities. For example, where an operator acts outside of its mandate from the responsible party, that operator can be seen as a responsible party in themselves. Okay, looking at the where does the Act apply? The Act will apply where the responsible party is domiciled in South Africa, and domicile really just refers to permanent residence. It will also apply where the responsible party is a foreign person, but the means used to process the information is in South Africa. So where you are a South African service provider that processes data in South Africa on behalf of a foreign responsible party, that data will be governed in terms of POPIA. Be aware, however, that if you have European responsible parties and you are a South African operator, there may be overlap in application between GDPR and POPIA, as GDPR applies where the controller is in the EU, regardless of where the processing takes place. Okay, turning to what the Act applies to. Personal information must relate to an identifiable, living, natural person, or where applicable, an identifiable existing juristic person. What constitutes personal data is very broadly defined and includes personal attributes such as gender, race, and ethnicity, historical information like educational, financial, criminal, or employment histories, identifying numbers like your ID number or passport number, email addresses, physical addresses, and even your views and opinions, including other people's views and opinions of the data subject. Also included in personal information is biometric information, such as retinal scans, fingerprints, and voice data for voice recognition. A person's name will be regarded as personal information if it appears with other information about them, or if its disclosure would reveal information about them. Certain categories of personal information are regarded as special personal information, and generally speaking, processing of this information is prohibited except in certain limited situations. Special personal information includes religious or philosophical beliefs, race or ethnic origin, trade union membership, political persuasion, health or biometric information, the criminal behavior relating to an alleged offense. The Act also provides specific requirements when processing some of these categories of special personal information, such as religious information, race, health, or biometric information. There are also specific provisions around processing children's information. Processing of data has been very broadly defined and covers most activities that one can perform on information, including collecting, recording, organizing, storing, modifying, retrieving, consulting, using, transmitting, making available, merging, and destroying. Okay, now the million-dollar question, why should your organization comply? Well, firstly, by being responsible and accountable through compliance with the Act, The organization creates trust and confidence amongst its employees, its customers, and its suppliers. And this trust could lead to a competitive advantage over non-compliant market players. Secondly, as we'll discuss later, POPIA requires organizations to protect personal information from loss, damage, and unlawful access. So complying with the Act would put the organization in a better position to prevent, detect, and mitigate the fallout from attacks. Protecting one's reputation should be at the forefront of any organization's key objectives. A data breach can have disastrous effects for the organization. In addition, the internet and social media have created such a fertile dumping ground for opinions and negative information that spread at lightning speed, with the result that the company's reputation could be irreparably damaged overnight. And finally, there's the financial and other punitive costs involved. Administrative fines can be levied of up to 10 million rand. There's a threat of imprisonment of up to 10 years. A breach incident could have a potential impact to the organization's share price. And there is potential for civil liability, which, as we'll discuss later, is much more severe. And after all that, the business would still need to go about implementing data protection controls to comply with the Act. A recent IBM study on the financial cost of data breaches for August 2019 to April 2020 revealed that it had cost South African companies on average 40.2 million rand per breach among the companies that were studied, and that was before any fines were levied. Now let's take a look at some of the key features of the Act, and in particular, the following four areas. The need to have a lawful basis for processing personal data, the importance of identifying and documenting the purpose of that processing, what data subject rights have been expressly provided for in the Act, and finally, what the organization must do to protect the data. So looking at the lawful basis, for processing to be lawful, it must be conducted for a lawful reason. It must not infringe the data subject's privacy. It must be adequate, relevant, and not excessive, considering the purpose of processing. There are 6 legal grounds on which information can lawfully be processed. Firstly, consent. Consent must be proven by the responsible party, and the data subject may withdraw their consent at any time, in which case the responsible party needs to stop processing. But bear in mind, where processing is based on another ground other than consent, the data subject cannot stop processing by withdrawing their consent. Secondly, where processing is necessary either to conclude a contract with the data subject or to perform in terms of such a contract. For example, a service provider may require your bank details or your credit card number to conclude a contract to ensure that you will pay during the existence of the contract. And they may also require an email address or physical address to provide you with invoices, which they may be obliged in terms of the contract to do. Third ground is legal obligation, and this is where processing is necessary for the responsible party to comply with a particular law to which they are subject. The easiest example is the banks, where they obtain proof of your identity and proof of your residence to comply with any anti-money laundering legislation. The data subject's legitimate interest is one of those grounds where the data subject can object to processing. And this is really where processing protects the legitimate interest of the data subject. For example, where the data subject is a charity and a donor requires its bank details to make a donation. The data subject, as I said, then reserves the right to object to processing in that instance. Secondly, where processing is necessary for performance by a public body of a public law duty, unless the data subject has objected and there is no law requiring the processing of data. So we see a second ground on which the data subject can object to the processing, but only where there isn't a law mandating that processing. So an example of this would be submitting your personal information to the licensing department, which is a public body that has a legal duty to maintain a record of all vehicle ownership. And then finally, processing can take place for the responsible party's legitimate interest. An example of this would be where the data subject collects proof of your bank account. The responsible party is a company and they require a potential supplier's proof of bank account or proof of registration. Their legitimate interest in that case is to prevent fraud being perpetrated. In this instance, the data subject does have the right to object to processing for the responsible party's legitimate interests, but that objection needs to be based on reasonable grounds. Where businesses rely on this as a basis for processing, and I believe that this is going to be increasingly relied upon by businesses, they need to be very clear on what the legitimate interest is that they are pursuing, and they must ensure that the information being processed is actually necessary to achieve that pursuit. Remember that these are the grounds for processing personal information in general. Processing special personal information is generally prohibited, except in certain limited situations, for example, where the data subject has consented or where the information has deliberately been made public by the data subject. Okay, now central to the Act is this concept of processing for a specific purpose, and the importance of purpose specification is threefold. Firstly, the Act requires that the data subject be notified of the purpose of processing to enable them to make an informed decision on whether or not to hand over their information. Secondly, purpose specification is also important for the responsible party to determine whether the processing is actually lawful and based on the grounds that we just discussed. And then finally, it's important to establish for how long that information can lawfully be retained. It is therefore really important that organizations know and document what data they are processing and for what purposes. But Chris will look at how some of the technology can facilitate data discovery. Subject to certain exceptions, the general rule regarding retention states that the responsible party may not retain personal information any longer than necessary for achieving the stated purpose, after which the responsible party must either permanently delete the information in a way that prevents it being reconstructed or de-identify it. Now, de-identifying information is either to delete any information that identifies the data subject, to delete any information that can be used or manipulated to identify the data subject, or to delete information that can be linked to other information that identifies the data subject. So what do I mean by this? As an example, if you have medical information relating to a particular patient and you delete their name and ID number and any other information that can be used to identify them, but if you have given them a reference number, which in a separate database is linked to their name, you would need to delete that record in the database in order to properly de-identify the information. So there's that element of permanence to the deletion or to the de-identification. Traditionally, organizations tended to retain information indefinitely. However, increased data means increased risk and increased cost. And as a result, we're seeing more and more customers adopting retention policies for their data and leveraging technology to automatically delete information when it can no longer be lawfully retained. And Chris will speak a bit about retention and records management technology. Okay, the Act affords the data subject with the following key rights. Firstly, the data subject has the right to be notified that their personal information is being collected and from where. And simply telling a data subject that their information was obtained from a database will not be sufficient. They also need to be told when their personal information has been accessed or acquired without authorization. For example, in the case of a breach. We've already seen that they must be notified of the purpose of collection, but they must also be told if disclosure is voluntary or mandatory. All this information must be given to the data subject before collection or as soon as reasonably practicable afterwards. Data subjects have the right to receive confirmation that their data is being processed and to receive this free of charge. They also have the right to request for a reasonable fee the record in question or a description of the personal information. The Promotion of Access to Information Act, which acts in parallel with POPIA, lays out grounds where the responsible party can refuse access. A responsible party must take reasonably practicable steps to ensure that the information is complete, accurate, not misleading, and updated, where necessary, considering the purpose for which it is processed. A data subject therefore has the right to request that the responsible party correct or delete personal information that is inaccurate, irrelevant, excessive, out of date, incomplete, or obtained unlawfully. In this case, where reasonably practicable, the responsible party must inform each third party to whom they have transmitted that information of the data subject's request. As we saw earlier, the data subject has the right to object on reasonable grounds to the processing of their personal information, where it's based on the responsible party's or the data subject's legitimate interest, or where processing for a public law duty unless there is a specific law requiring it. If they object, the responsible party must stop processing. The data subject has the right to object to processing of their personal information for purposes of direct marketing, which is specifically defined as to approach a data subject either in person or by mail or electronic communication for the direct or indirect purpose of promoting or offering to supply them with goods or service in the ordinary course of business, or with the purposes of soliciting a donation from the data subject. Electronic communication is also specifically defined. Now, direct marketing by unsolicited electronic communication, which is all too common in our country, is only permitted in certain limited circumstances. For example, where the data subject is an existing customer and they have not previously objected. Data subject also has the right not to be subject to automated processing. So the data subject has the right not to be subjected to a decision based on automated processing of their personal information, which is intended to create a profile of that person and which decision results in legal consequences for them or affects them substantially. Now, those are two very important limiters. So if you think of a standard advertising on a website where, they will look at your shopping history to develop that profile, you could argue that there is no legal consequence and it doesn't affect the data subject to a substantial degree. Some of the areas in which automated decision-making may not occur are around the individual's creditworthiness, their reliability, their location, and their health. Many companies are leveraging artificial intelligence or machine learning to plow through vast amounts of data in order to extract business intelligence. An obvious example would be organizations that use these types of systems to analyze loan repayment behavior, earnings, and asset ownership information to create a credit profile and use this information to determine whether or not they should extend credit. These are the sort of situations that POPIA has in mind. So companies need to be very circumspect when engaging automated decision-making systems to ensure transparency and compliance with the Act. Data subject has the right to submit a complaint to the regulator regarding any alleged interference with the protection of their personal information. The Act outlines a process for the data subject to follow in order to submit complaints to the regulator. And then finally, the data subject has the right to institute civil proceedings, either themselves or through the regulator, in a court having jurisdiction for the alleged interference with the protection of their personal information as specifically defined. What's important to note here is that action can be brought regardless of whether there is any negligence or intent on the part of the responsible party, though there are certain defenses that can be raised. And this is a major deviation from most civil liability claims, where the plaintiff must prove either negligence or intentional wrongdoing on the part of the defendant in order to succeed in their claims. Okay, let's see what the obligations are around protecting the data. The Act outlines the responsible parties and the operator's responsibilities to protect personal information being processed. Stick around for our section on top tips as we make some suggestions in this area. The Act suggests that a responsible party and an operator must secure the integrity and the confidentiality of personal information in its possession or under its control by taking appropriate, reasonable, technical, and organizational measures to prevent loss of, damage to, unauthorized destruction of that information, or unlawful access to the information or its processing. So the words organizational or technical means that it's people, process, and technology controls that need to be implemented. So central to this obligation is the need to follow what's called a risk-based approach. But what does that mean? The responsible party and the operator must firstly identify all reasonably foreseeable internal and external risks to the information. They must establish and maintain appropriate safeguards against those risks. They must regularly verify that the safeguards are effectively implemented, and they must ensure that the safeguards are continually updated in response to new risks or deficiencies in previously implemented safeguards. Companies traditionally place a lot of emphasis on external risks and employ a variety of measures to protect their data from these risks, such as implementing malware protection software and conducting penetration testing. What's often less considered is the risk posed from within the organization, particularly in these times where management's attention could be focused elsewhere. After all, external hackers need to break through your defenses, but your staff have the keys to the castle. Microsoft have really developed some exciting technology aimed at protecting organizations against this insider risk. A responsible party must, in terms of a written contract between the responsible party and the operator, ensure that the operator processing personal information fulfills the same obligations to protect their personal information. Information processed by the operator or anyone on behalf of the responsible party must only be processed with the knowledge or authorization of the responsible party and must be treated confidentially. Where the operator exceeds its mandate, it could be regarded as being a responsible party in that instance. The operator must notify the responsible party immediately when there are reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized party. And where there are reasonable grounds to believe that there has been unauthorized access or acquisition of personal information, the responsible party must notify the regulator and the data subject in writing as soon as reasonably possible after the discovery. Now let's take a look at some of our suggestions on how you can get started on your POPIA compliance journey. Firstly, appoint your information officer. POPIA requires all public and private bodies to appoint an information officer to ensure compliance with the law, deal with requests made of the organizations in terms of the Act, and to work with the regulator on investigations. Now, although information officers must only take up their duties only after they've been registered with the regulator, and since the regulator has not yet finalized the registration process, we would still recommend that you designate or appoint your information officer and ready them with the resources they require to fulfill their duties. Secondly, discover and document all personal data being processed and all processing operations within your organization, identifying the legal basis on which that processing is being conducted. Conduct a risk assessment. It's really important to understand where personal information is being processed in your organization and what controls you currently have in place to protect it. One of the workshops we offer is directed at helping customers identify where their control gaps are and how to remediate those deficiencies. Get your policies in place so that internal and external stakeholders are aware of how your organization is and must be protecting personal information. Create privacy notices informing data subjects whose information you process, what types of information you process, how it is processed, including what retention periods are applicable. Also be sure to ensure the contact details of your information officer. Post links to these privacy notices in email signatures and on your websites and social media pages. Ensure that your employment contracts are updated to establish clear guidelines on how personal information must be handled and to outline the consequences of a failure to comply. Update your agreements with suppliers, especially those processing information on your behalf, to ensure that they process information only as per your express written instructions and to ensure their compliance with the provisions of this Act. Establish and document retention policies for personal data within your organization to ensure that data is only retained for as long as it is required for purposes of its processing. Leverage technology to facilitate data retention and deletion requirements. Create and reinforce awareness of the Act and the importance of protecting data within your organization. The commitment of every employee is pivotal to successful implementation of data protection controls. I will now hand over to Chris, who will take you through some of the technology.
Thanks, Kelly. So it falls on me to talk through some of the ways using technology will ease the burden and help you manage data privacy. The three important layers of people, process, and only then technology can't be bypassed. But in reality, most organizations will not be able to meet their compliance goals without sensible use of technology. And in this regard, the IT teams within organizations also need to step up from the days of old and keep themselves relevant to the organization by understanding the tools and facilities that meet these business requirements. The days of managing infrastructure, operating systems, and even some applications are now well behind us in the cloud era. The first thing I want to cover and to understand is that there are different types of information within the organization, and the requirements and complexity of getting control can vary greatly depending on the data and the workloads in question. Structured data is found in financial systems and inline business applications. The compliance requirements and privacy requirements are often built into the business logic of the application. And the tabular nature of these systems means you know where specific types of content will be. It's also much easier to apply machine learning to these systems for valuable insights and efficiency, but also to protect the sensitive information. Unstructured data is that randomly generated user data that probably accounts for up to 80% of your data and grows exponentially over time. In its worst form, it's unmanaged, difficult to find, and use for anything useful, and often contains the smoking guns from a risk perspective. Semi-structured data is the area we're most interested in, as the more we can apply systems and give users platforms that generate semi-structured rather than unstructured data, the better off we'll be as we're able to extract value, apply and enforce the routines that protect the content. Machine learning in combination with human training or classifiers are going to take this content to very new heights in the coming months, if not years. It really is just around the corner. Regardless of the type of data, the objective is to gain an advantage by reducing risks and increasing compliance, reducing operational costs and getting value from the data through sharing and reusing it and reusing the knowledge it contains. I think that's going to be really important as we move forward into the ML, or what's often called AI era. Data is exploding, and this itself is a big part of the challenge, especially with the evolving regulations in almost all regions of the world. GDPR in the EU and POPIA here in South Africa being prime examples of this, and ones that affect many of our customers, even the local ones, on a daily basis. So as we look to the overwhelming amount of challenges and begin to feel overwhelmed by the compliance evolution and the data revolution, as Kelly calls it, we face these security challenges, the data subject requests and defensible deletion, specific disposition and retention policies. The one big thing that has stood out for me in the last few years is the complexity, cost, and number of IT systems organizations have had to deploy and manage to win this battle. The need to simplify, rationalize, and centralize all those point solutions to manage what are ultimately commoditized requirements most modern organizations need is well overdue. For us as content management and governance-focused organization, no other solution has managed this more effectively in the unstructured data space than Microsoft's Office 365 Enterprise Suite. Looking at the Office 365 Suite as simply a replacement for on-premise platforms we run for file, email, messaging is a complete misunderstanding of what's available to you. Much of the planning we do with our customers is to replace one point solution after the other, not only to assure they're getting the value for money from the platform and the licensing they're paying for, but also to centralize control and to deliver integrated governance features business and the users need. There are a few baseline requirements when deploying Microsoft's modern workplace platform, but with no additional infrastructure or application development and the appropriate licensing and guidance, you can quickly start using advanced features, such as in the example you can see here. Here we can build classifiers that automate classification and actions based on, in this example, most of the Office 365 estate, SharePoint, OneDrive, Exchange, the content types. So we're using metadata, keywords that may exist within the content. We can also apply some of the pre-built and templatized sensitive data information types in our programming. We can also develop what we call regular expressions and customized sensitive information types that we may need as an organization. And then at the extreme end of it, we can also start using the machine learned capabilities within the platform, which allows to identify things like resumes, which are obviously a font of sensitive information, contracts easily. And once we've identified and we've met all these requirements, we can then classify the content. But the classification is more than just a label. What it does is it actually drives actions, and it drives the policies that we've put in place. So for in this example, we may retain it for 7 years and then dispose of it defensively. Or we'll have a level of immutability where we won't allow versions, or we will have version control. We can also enforce, make sure there's enforcement at the point of consumption by allowing users to share internally only or externally, as the case may be. The Microsoft 365 ecosystem also presents a great opportunity for getting your broad data governance house in order. All too often, when the combination of the IT management teams and the risk and compliance departments are not aware of the deeply integrated and centralized security and governance elements that are available to them, what we find is we need to take our customers on a journey to create the awareness and to allow them to mature, so that they can manage the risks in a world of ultra mobility and easy collaboration that we exist in today. Getting a security and governance baseline is a critical starting point for cloud adoption and a great way to bring business into the fold. The process needs to be documented and agreed with both IT and business stakeholders so that the licensing, retention, identity access, and administration control requirements are matched to current and future requirements, and that a rhythm of measuring and maturing your governance and stance is established. More advanced cybersecurity design and deployment is also an important element of governance, and often an easier starting point for the IT team. With evolving security threats and the constant release of new features, there can be additional licensing and cost implications, and this responsibility should also be spread out to the business and risk management teams to ensure that business functions are properly supported with appropriate data leak prevention policies that actually have teeth, or alerts for shadow IT and anomalous behavior within the organization. Identity management is another key area for privacy. From shoring up security by rationalizing unnecessary legacy identities and directories, to conditional access policies to lock down remote working scenarios that we all live in today. One of the most interesting requirements we are seeing is to provide the ability to securely federate with external cloud systems such as Salesforce and others, or even facilitating business-to-business requirements between organizations who need to work together or share information in data rooms. This is all actually made easier by using cloud identity and the access management features. The Compliance Center is another often overlooked facility and provides governance teams with direct access to the state of compliance and progress against governance initiatives such as complying with POPI and getting to those requirements. A central point of retention and disposition and legal hold in a single system also greatly reduces the burden on search and data subject requests and even e-discovery requests. Traditionally, these requirements needed to be coordinated across several point solutions that required an over-reliance on multiple IT personnel and functions, often not the ideal location for these responsibilities, especially where there's sensitive data involved. We've started working on some interesting projects with our customers as they leverage their investment in the licensing, security, governance, and compliance ecosystem they've developed in Office 365. Getting more of your content out of those legacy systems and into Office 365 is a very effective way of reducing costs and increasing the control. Here are a few examples we're working with. Most of the organizations we deal with have large legacy email and file archives that are stuck on outdated and costly platforms. We've been able to develop cost-effective approaches to migrate the content into the Office 365 platform or closely connected Azure-based systems obviously reducing costs and increasing that control again. Similarly, the days of rampant and uncontrolled file shares and emails and PST files on file servers and on-site SharePoint content can be neatly brought into line with online alternatives that offer a fully managed, protected, and governed platform with the same investment and none of the on-site overheads. M&A activity and legacy geographic or corporate silos are another area of unnecessary cost and complexity. There are very few organizations who can truly justify these structures regardless of the size and breadth of the organization in the modern cloud. They really need to be brought under the same system of control, almost no matter how global the organizations are. Another new and fast-growing area of interest is the records management function. This can also be a handy addition to the advanced governance licensing SKUs and isn't always given its due value, as it can be seen as a sort of separate project requirement that potentially lives with another department not currently involved in the conversation. We're also seeing an exciting new breed of matter and content management tools that are designed to run on the Office 365 ecosystem and leverage those investments rather than yet another proprietary backend and siloed platform with all its own infrastructure and issues. Perhaps for us as content team, the most exciting area of development is loosely related to enterprise search and knowledge management space. Here we're creating the opportunity to use the cognitive services previously only seen with highly specialized niche providers of machine learning solutions, mainly in the legal industry. In particular, you'll hear more about SharePoint Syntax that launches in October. And this offers a contract review and clause level analysis that formerly required us to use very specialized tools. Syntax allows us to extract the details within documents such as the expiration date or values within contracts stored in Office 365. These facilities have been democratized into the M365 framework, along with insider threat detection, trader surveillance, and many more highly advanced features. As I mentioned, as specialist content management partners, we try to provide solutions that leverage both our advisory as well as our technical skills in coherent solutions that meet the challenge you're facing, such as here with POPI. A good example of this is our data risk management solution, where Kelly and her team take you through workshops that will identify key issues and challenges with data privacy, and then map the actions and technical solutions that are available to you in each area of concern. Our technical teams are then able to run a discovery process that leverages the tools and systems available to you to identify dark and sensitive data, which is then analyzed, allowing us to provide you with an appropriate recommendation or tools and services, as well as the next steps, like our detailed data classification or taxonomy process that helps you protect information at the appropriate levels, time, and place. So for me, that's all on the technology side of it, and I'll hand back over.
Fantastic. Thank you so much, Chris. We're now going to move into the Q&A session for today. And we have a question here. So I'm just going to read it out, and then Kelly or Chris, you can just decide who's going to run with it. The question is from Vaughan. A lot of meetings are getting recorded at the moment. He asks if this is a risk in terms of POPIA.
So Vaughan, thanks for the question, and it really is a good one. There are a lot of facets to the situation. It's not a simple yes/no issue. It boils down to, first of all, what is the purpose for the recording? Are they internal meetings? Are they meetings with customers? What I've seen come up a lot with with our customer meetings is, particularly webinars, where they say, if you do not want your opinions to be recorded, basically do not participate in this meeting. And I have an issue with that for a couple of reasons. The first of which being the GDPR as an example, and it's very similar to POPIA. The GDPR states that if you're forced to consent to processing of information as a condition of being given a good or being sold a good or a service, then your consent is not freely given. So what that means is, say, for example, Facebook sends you a form, and this is really a ridiculous example, but Facebook sends you a form where you have to fill in your sexual orientation. They don't need that information to provide the social networking service. And if they make you giving that information conditional on them giving you the service, then your consent is not regarded as freely given. So now if we go back to that sort of situation with meetings where, say, if you don't want to be recorded, don't participate in the meeting, and it's a big organization that I know did this, you can say, well, is it really necessary that I be recorded? Is that necessary for the purposes of this meeting? So it's really going to be circumstance dependent. And you know, because there are a lot of problematic areas there. There's the issue of information needs to be, you know, updated, accurate. You know, if you say something that is false in the course of a meeting and you subsequently retract it by way of an email, you're bound by that recording. So yes, there are a number of issues involved that do need to be determined, but it's very much going to boil down to what is the purpose of the recording, what they're going to do with it. Does that answer your question?
One thing I would add to that is that, you know, making sure you've got a control framework in the back, or that you've got privacy, you've got identity and access management, so that the right people have access to that meeting. And one of the things that has come up actually with that is, you know, allowing who has access to that recording, and then if they do have access, it's generally the people who are participants in that recording will have access. But in some cases, for example, internal disciplinary hearings, you may not want them to have access to those recordings. So there are some funnies, and there are some ones that we are working through with customers, but certainly being able to fall back on that safety net of being able to protect the access and control and management of the information if it is recorded is obviously very important. And then two, being able to find it. So the fact that in Teams meetings, for example, it is transcribed into text and will become searchable, so that you can find the information, whether it is for whether it's for a DSARS event or in an e-discovery process, is also important.
Okay, thank you so much. Okay, I do have one more question that's just popped up now. There is no name to it, but the question is, how do we expect the regulator to assess the concept of an unstructured data?
I think the regulator, and Kelly, you can probably back me up or correct me if I'm wrong. I think the regulator is going to say that it's not an excuse to have unmanaged or dark data. So it's not an excuse to say, well, I couldn't find it in my own data estate, so therefore it's not my fault. I think that the regulator is going to expect you to use people, process, and technology to sort out, discover, find where the information is. Obviously, that in some organizations, that could be a really big, hairy job. But it's a fact, you know, there are tools available. There are ways of finding sensitive information. There are ways of finding information that belong to specific people using, you know, modern indexing systems and modern platforms. So again, I would really encourage people to make sure they're running platforms that can meet these requirements in an appropriate time frame, because that's the other thing, is it's not an excuse to say this data was somewhere in unstructured data, so therefore it took me a long time to find it. You need to find it in a reasonable time frame.
Yeah, absolutely. Hey, one of the first things they taught us at law school was ignorance of the law is not an excuse. And it's important. That's why we advocate for creating awareness amongst your organization about the importance of data privacy. So, because very often, I mean, I know my staff will raise issues with me that I hadn't thought of. So you absolutely need to know what your data is. And it's going to be a process to go through and see what personal data you're processing, what are the purposes you're processing it for, how long are you retaining it. You know, this is an exercise that every organization needs to go through, and the regulator's attitude is going to be, well, you've had a year to do it, you know, and a year is not a long time in those terms. So I think she is the liabilities are very fierce. They're very punitive, as we saw from a civil liability perspective. The fact that there is actually prison time, that there is extensive fines, you know, she's not going to pull her punches. And I think that that people need to use what's left of this 12-month grace period to really have a good hard look at what they're doing with personal data, how they're protecting it. And it's not just the obvious, you know, it's your employee data as well. It's the CVs that you get in, or the resumes that you get in when you're recruiting for positions. And you think to yourself, oh, well, I'll keep this one in case a suitable position adds up. Can you do that? So yeah, my advice is just get going. The top tips we've given you are, I think, a great way to start. But get going now. Don't wait around for 1st of July next year or 30th of June next year. Thank you very much for your time today. Feel free to reach out. We're happy to have some discussions around what we can do for you, how we can help you. We know it's very overwhelming, especially if you have not been through the GDPR process before and you're starting from scratch. So more than happy to help along with that.
Thank you, Chris and Kelly. And then from Cloud Essentials, thank you so much for joining us today, and we hope to see you all soon. Take care, good afternoon, and goodbye.
Thank you.